Press the bell icon on YouTube and don't miss another update.
If there is one case which has been in judicial cold storage for over 135 years, having a chance to impact the lives of millions of Indians, it is the Ayodhya land dispute. The Supreme Court of India would start hearing the appeals in the land dispute case from August 6, which would finally put an end to a burning question. Whose land is it? Is it the place where Lord Rama was born, or was it the site of a mosque that was demolished in 1992? This hearing is soon after the court-ruled mediation panel headed by former Supreme Court Judge Justice Fakir Muhammad Khalifullah failed to resolve the dispute. ThePrint takes you back to 1885, where it all started. In 1885, the dispute landed in the court for the first time when Mahant Raghubar Das filed a suit in a Faizabad court seeking permission to construct a temple on the Ram Chabutra. The next batch of litigation started on December 23, 1949, when a mob of 50 to 60 people laid siege to the mosque and placed the idols of Ram and other objects right under the central dome. Paramahansa Ramchandra Das and Gopal Simla Visharad filed a suit for continuation of worship and keeping the idols. Later in 1990, Ramachandra Das withdrew his plea while Visharad continued fighting the case. In 1959, Nirmohi Akhada, one of Ayodhya's oldest religious institutions, filed a suit seeking transfer of charge of the disputed site from the receiver. On December 18, 1961, the Uttar Pradesh Sunni Central Waqf Board filed a suit for the declaration in possession of the Babri site. In 1986, a local court ordered the government to give access of the site to Hindu worshippers. Bhagwan Ram Lalla Virajman joined the litigants' list after a gap of 28 years in 1989. After this suit was filed, Bharatiya Janata Party joined the movement officially.
संकल्प को कोई टाल नहीं सकता, कोई रोक नहीं सकता, और आज की यह सभा एक प्रकार से उस संकल्प पर मोहर लगाती है. बहुत बहुत धन्यवाद.
In 1989, Allahabad High Court also ordered to maintain status quo in respect of the disputed structure. On October 10, 1991, it was the Kalyan Singh government which then acquired 2.77 acres of land around the disputed dacha or the site. Well, in December 6, 1992, Babri Masjid structure was demolished. Post-demolition, the Narasimha Rao government took some 67 acres of land all around the disputed area. Government also asked Supreme Court to decide whether a Hindu place of worship predated the construction of the masjid. The Supreme Court then declined. In 1993, acquisition of certain area at Ayodhya Act passed for acquisition of land by centre in the disputed area. This act was challenged by several writ petitions, including one by Ismail Faruqi, filed in the Allahabad High Court challenging various aspects of the act. In 1994, the Supreme Court said that the Ismail Faruqi case, where it stated that mosque was not integral to Islam. In 2002, Allahabad High Court begins hearing civil suits determining who owned the disputed site. In 2003, in the Aslam alias Bhure case, Supreme Court ruled that no religious activity of any nature be allowed at the acquired land. In 2010, the Allahabad High Court, in a 2:1 majority verdict, ruled a three-way division of the disputed area between Sunni Waqf Board, the Nirmohi Akhada and Ram Lalla Virajman. However, appeals were filed against the Supreme Court verdict in 2011. In 2017, the then CJI J.S. Keher suggested an out-of-court settlement. In August 2017, Supreme Court heard a plea on reconsideration of the Ismail Faruqi, but however declined to do so in 2018. In December 2017, 32 civil rights activists filed a plea challenging the 2010 verdict of the Allahabad High Court. In January 29, the centre moved to Supreme Court seeking permission to return the 67 acres of acquired land around the disputed site to original owners. In February 20, Supreme Court decided to hear the case on February 26. However, on March 8, the Supreme Court referred the dispute for mediation by a panel headed by former Apex Court Judge Justice Khalifullah. Other members were Senior Advocate Sriram Panchu and Sri Ravi Shankar. It was on 1st August 2019 that a 5-judge bench headed by CJI Ranjan Gogoi stated that mediation was unsuccessful and that day-to-day hearing would start in the case from August 6 onwards. Well, with the Chief Justice of India Ranjan Gogoi set to retire on November 17, he has approximately 48 to 50 days to wrap up the hearing of the Ayodhya land dispute case and deliver a verdict in the same. This is inclusive of the Diwali and Dussehra holidays of the top court. In case the Chief Justice of India is not able to complete the entire hearing and deliver a verdict before he retires, this case has to be heard from the very beginning before a new bench. Again, the questions will arise as to who will hear the case and what will be the bench formation in case the verdict is not delivered before CJI Ranjan Gogoi retires. So the big question remains, will the Ayodhya land dispute case be resolved before November 17? This is Debayan Roy for The Print. Please subscribe to our channel, theprint.in, and also like us and subscribe us on Twitter and Instagram.